Good afternoon, everyone, and welcome to the No Surprises Act, an overview for sisters, advocates, agents, and brokers webinar session. My name is Devin Key, and I will be your facilitator for today's webinar. Also with us today are subject matter experts from CMS who will be available to respond to your questions during today's session. This is a 60-minute webinar session. For questions regarding logistics and registration, please contact the registrar at 1-800-257-9520. Again, that's 1-800-257-9520. For your best webinar experience, we have included some webinar and audio tips. If available, please hardwire your device, closing any applications that aren't being used. You can reduce streaming activities as well as disconnecting from your VPN. And if you lose web connectivity, please switch to your phone for continued access. CMS would like to encourage all attendees to submit questions throughout today's webinar. To ask a question, simply type your question in the text box by selecting the Q&A button in your webinar controls. Immediately following today's presentation, CMS may verbally address some of those questions submitted. CMS will take back any unanswered questions for follow-up. Save the date. CMS will conduct a webinar on the No Surprises Act's Understanding the Good Faith Estimate and Patient-Provider Dispute Resolution Process on next Thursday, March 3rd. Please be on the lookout for additional information. And now that we have completed instructions for today's events, I will turn this session over to Jean Ann Scabera of CMS to begin our presentation. Jean Ann?
Thanks so much, Devin, and good afternoon, everyone. Here's the agenda for today's presentation. We're going to start by defining some important terms, talking about how the No Surprises Act helps prevent surprise medical bills, touch on the good faith estimate and patient-provider dispute resolution process, discuss some of the other protections for consumers, and talk about how consumers can get help. So first of all, some important definitions. What is surprise billing? Surprise billing happens when people unknowingly get care from providers that are outside of their health plan's network and can happen for both emergency and non-emergency care. Balance billing is when an out-of-network provider charges a patient the remainder of what their insurance does not pay. Surprise bills and balance bills affect many Americans, particularly when people with health coverage unknowingly get medical care from a provider or facility outside their health plan's network. This can be common in emergency situations when people usually go to or are taken to the nearest emergency department without considering their health plan's network. It can also happen when people with health coverage receive care from an out-of-network provider at an in-network facility. So now let's talk about how the No Surprises Act helps consumers in these situations. In this section, we'll talk about how the No Surprises Act prevents surprise medical bills, how a new requirement for good faith estimates will help consumers understand their costs in advance. We'll talk about a process that takes consumers out of the middle of a payment dispute between providers and health plans, and a separate payment dispute for uninsured or self-pay individuals. We'll also mention a few other provisions, including expanded rights to external review, new requirements for insurance ID cards, and new requirements around the accuracy of provider directories. So first, let's talk about how the No Surprises Act prevents surprise medical bills. The No Surprises Act and the implementing regulations ban surprise billing for emergency services. Emergency services, regardless of where they are provided, must be treated on an in-network basis without requirements for prior authorization. The regulations also ban high out-of-network cost sharing for emergency and non-emergency services. Patient cost sharing, such as co-insurance or a deductible, cannot be higher than if such services were provided by an in-network doctor, and any co-insurance or deductible must be based on an in-network provider rates. The Act and implementing regulations also ban out-of-network charges for ancillary care, like an anesthesiologist or assistant surgeon, at an in-network facility in all circumstances. They ban out-of-network charges for air ambulance services and ban other out-of-network charges without advance notice. Healthcare providers and facilities must provide patients with a plain language consumer notice explaining that patient consent is required to receive care on an out-of-network basis before that provider can bill at the higher out-of-network rate. Who is protected by the No Surprises Act? These surprise billing protections apply to consumers who get their coverage through their employer, including a federal, state, or local government employer, a multi-employer plan, or through the federal marketplace or a state-based marketplace, or who purchase coverage directly through a health insurance plan. For those who are uninsured or self-pay for care, this rule includes protections to ensure they know how much their health care will cost before they get it and have a way to challenge a bill if it is much larger than expected. The rules don't apply to people with coverage through programs like Medicare, Medicaid, Indian Health Service, Veterans Affairs Healthcare, or TRICARE, since each of these programs already has other protections against high medical bills. So how are patients made aware of these rules? The rules require certain healthcare providers and facilities to make publicly available, post on a public website, and provide to individuals a one-page notice about the requirements and prohibitions that apply to the provider or facility, any applicable state balance billing limitations or prohibitions, and how to contact appropriate state and federal agencies if someone believes the provider or facility has violated the rules. Beginning on January 1st, 2022, the No Surprises Act protects consumers from surprise medical bills in situations where they can't easily choose a provider who is in their health plan's network. As we noted, this is especially common in an emergency situation when they may get care from out-of-network providers. Out-of-network providers or emergency facilities may ask consumers to sign a notice and consent form before providing certain services after they are no longer in need of emergency care. These are called post-stabilization services. Note that a consumer should not receive this notice and consent form if they are receiving emergency services other than post-stabilization services. Consumers may also be asked to sign a notice and consent form if they schedule certain non-emergency services with an out-of-network provider at an in-network hospital or ambulatory surgical center. The notice and consent form informs consumers about their protections from unexpected medical bills. It gives consumers the option to give up those protections and pay more for out-of-network care, and it provides an estimate of what their out-of-network care might cost. Consumers aren't required to sign the form and shouldn't sign the form if they didn't have a choice of healthcare provider or facility before scheduling care. If they don't sign, they may have to reschedule their care with a provider or facility in their health plan's network. So when do these surprise billing rules take effect? The new rules related to surprise medical bills and balance billing take effect for healthcare providers and facilities January 1, 2022. For group health plans, health insurance issuers, and federal employee health benefits program carriers, the provisions take effect for plan, policy, or contract years beginning on or after January 1, 2022. So how are the out-of-network payments determined? The rules take consumers with job-based or individual health plans out of the middle of certain out-of-network payment disagreements and provide a process for providers, facilities, providers of air ambulance services, and health plans to negotiate those payments. The amount a consumer must pay is determined by a state payment agreement, state law, or the qualifying payment amount, which is generally the average in-network rate for the same or similar items or services for the health plan. Any additional amount to be paid by the health plan to the provider is negotiated between the health plan and the provider, first through a 30 business day open negotiation period. Then, if the parties fail to determine an amount, through a new federal independent dispute resolution, or IDR, process. The consumer is not involved in this process. Next, we'll talk a little bit about the good faith estimate and patient-provider dispute resolution requirements in the No Surprises Act. As we noted earlier, we will be doing a deeper dive into this topic next week, so stay tuned for that invitation. The No Surprises Act also protects uninsured or self-pay individuals from unexpected medical bills. Starting January 1st, 2022, a provider or facility has to give an uninsured or self-pay individual a good faith estimate of expected charges after an item or service is scheduled or upon request. The good faith estimate will include expected charges for the primary item or service the individual is receiving, as well as for any other items or services that would reasonably be expected to be provided as part of the same scheduled or requested items or services. For example, if a consumer is getting surgery, the estimate might include the cost of the surgery, any labs or tests, and the anesthesia that might be used during the operation. If an item or service is something that isn't scheduled separately from the surgery itself, it will generally be included in the good faith estimate. Other items and services related to the surgery that might be scheduled separately, like pre-surgery appointments or physical therapy in the weeks after the surgery, won't be included in the good faith estimate. The good faith estimate must be provided for an item or service scheduled at least 3 business days in advance within 1 business day of scheduling. For an item or service scheduled at least 10 business days in advance within 3 business days of scheduling. For an item or service that is not yet scheduled within 3 business days of the request. And the provider must include in the good faith estimate an itemized list of each item or service grouped by each provider or facility offering care. Each item or service has to have specific details and the expected charge. It must provide a paper or electronic copy of the good faith estimate, even if the provider also provided the good faith estimate information to the consumer over the phone or verbally in person. And the provider must provide the good faith estimate using clear and understandable language. Note that in 2022, providers will not be required to include estimates from the other providers involved in the individual's care. Individuals may separately ask those other providers for a good faith estimate. The provision will be enforced beginning in 2023. So what happens if the bill is more than the good faith estimate? Consumers may use a new dispute resolution process if they are uninsured or self-pay and get a bill for an item or service that's substantially greater than the expected charges in the good faith estimate. Under this process, consumers can begin dispute resolution with the provider when the actual billed charges for a particular provider or facility are at least $400 more than the good faith estimate received. Consumers have 120 calendar days from the day they get the initial bill to begin the process. In this process, a third-party dispute resolution organization reviews the good faith estimate, the bill, and information submitted by the consumer and their provider or facility. The third-party dispute resolution organization will use this information to determine if the consumer must pay the additional charges or if the consumer can only be charged what was on the good faith estimate or some other amount lower than the bill. To offset some of the costs of operating the dispute resolution process while keeping it accessible, HHS will charge consumers an administrative fee of $25 in 2022. However, if the resolution ends in the consumer's favor, this fee will be credited back on their bill by the provider or facility. So what happens during the dispute? During the patient-provider dispute resolution process, the provider and patient can continue to negotiate the bill. During this process, providers may not move the bill into collections or threaten to do so, must pause collections if the bill is already in collections, cannot collect late fees on unpaid amounts, and cannot threaten to take any retaliatory action against the patient for initiating the patient-provider dispute resolution process. If the patient and provider agree on a payment amount, the provider is required to reduce the bill by at least half of the $25 administrative fee. Now we'll talk about some of the other protections in the No Surprises Act. The external review process allows individuals with group or individual health coverage to appeal a payment for a healthcare item or service that was denied by their health plan due to an item or service not being covered, restrictions on coverage, or the item or service not being considered medically necessary by the health plan. Under the No Surprises Act and implementing regulations, coverage decisions that involve whether a health plan is complying with surprise billing and cost-sharing protections are now eligible for external review. So let's take an example. A consumer's plan or issuer covers emergency care under the No Surprises Act, and the consumer gets care at an emergency room. But the consumer's health plan denies payment because it doesn't believe the items or services were emergency services. The consumer could appeal this decision using the external review process, which will help determine whether the health plan needs to cover the care received. Also starting in 2022, new pricing information will be shown on any physical or electronic plan or insurance identification cards provided to patients. This information will include applicable deductibles, applicable out-of-pocket maximum limits, and a telephone number and website where consumer assistance will be provided. Additional information may be provided on a health plan's website that can be accessed through a quick response code, commonly referred to as a QR code, on a physical ID card, or through a hyperlink on a digital ID card. There are also some continuity of care requirements. The No Surprises Act protects continuing care patients in circumstances where their treating providers or healthcare facilities plan network status changes, allowing a 90-day transitional care period. During this time, health plans and issuers must limit cost sharing to in-network terms. Treating providers and facilities must accept cost sharing and payments from plans and issuers as payment in full. Continuing care patients are defined as individuals who, with respect to a provider or facility, are at least one of the following: undergoing treatment from the provider or facility for a serious and complex condition defined as A, in the case of an acute illness, a condition that is serious enough to require specialized medical treatment to avoid the reasonable possibility of death or permanent harm. Or B, in the case of a chronic illness or condition, a condition that is either life-threatening, degenerative, potentially disabling, or congenital, and requires specialized medical care over a prolonged period of time. 2, undergoing a course of institutional or inpatient care from the provider or facility. 3, scheduled to undergo non-elective surgery from the provider or facility, including receipt of postoperative care from such provider or facility with respect to such a surgery. 4, pregnant and undergoing treatment for pregnancy from the provider or facility. Or 5, terminally ill and receiving treatment for such illness from the provider or facility. Also beginning January 1, 2022, plans and issuers must update and verify the accuracy of provider directory information and establish a protocol for responding to requests by telephone and electronic communication from a participant, beneficiary, or enrollee about a provider's network participation status. Under the No Surprises Act, if an individual relies on incorrect provider directory information and as a result receives items or services from an out-of-network provider or out-of-network healthcare facility, their plan or issuer must limit cost sharing to in-network terms that would apply had the items or services been furnished by an in-network provider, and apply the deductible or out-of-pocket maximums as if the provider or healthcare facility were in-network. Their provider or healthcare facility must not bill an individual more than their in-network cost sharing. And now I'll turn it over to my colleague, Patrick Edwards, Director of the Division of Consumer Services, to talk about how consumers can get help.
Thanks, Shanann. So good afternoon, everyone. I'm here today to talk about a new help desk that is available to consumers and providers who need assistance navigating the new rights and protections under the No Surprises Act. On January 1, we launched the No Surprises Help Desk that provides a no wrong door approach to users that intakes, reviews, and triages potential violations of the No Surprises Act and addresses general inquiries about their new rights and protections under the Act. Users have the option of contacting our staffed help desk through our toll-free 1-800 phone number, as displayed on the screen, 7 days a week between the hours of 8 a.m. to 8 p.m. Eastern Standard Time, or by utilizing the complaint web forms that are posted on the CMS No Surprises website. Our complaints landing page also provides helpful tips on how to complete our web form, what documentation may be needed, and a summary of what happens during the complaints process. Our help desk offers bilingual help desk representatives, specifically English and Spanish, a language translation line that offers more than 200 languages and uses interpreters who have expertise with medical terminology, and English and Spanish interactive voice responsive services. Our help desk allows our external partners to receive complaints under their jurisdiction so that users always feel like they have come to the right place. Additionally, even if the complaint or inquiry is not related to this No Surprises Act, we will intake and triage those users to the appropriate state or federal resolution process to promote an efficient and positive consumer experience. Once a user submits a complaint, they will receive an acknowledgement that their complaint was successfully submitted, a ticket number associated with their complaint, and a summary of next steps. Additionally, at any time throughout the complaints process, users can contact the help desk for additional assistance or status update regarding their complaint. Next slide. So what the help desk can do. Our help desk will review the complaint to make sure that the insurance company, medical provider, or healthcare facility follow the No Surprises billing rules. We will investigate and enforce federal laws and policies under our jurisdiction. We will try to identify patterns of problems that may need further review. We'll assist consumers with understanding what documentation they need to submit or what next steps they should take to address their issue. And lastly, we'll help answer questions or direct consumers to others who can. Next slide. So what the help desk can't do. We can't require medical providers or healthcare facilities to adjust their charges. We can't act as a lawyer or give legal advice. We can't make medical judgments or determine if further treatment is necessary. We can't determine the value of a claim or the amount owed to consumers. And lastly, we can't address any issues we can't legally enforce. I also want to note that our help desk may refer consumers to their state consumer assistance program if the consumer is still experiencing issues with their health insurance, request assistance with filing an appeal, or would like additional information about health coverage options not related to the No Surprises Act. Thanks. I think back to GM.
Thank you, Patrick. So here are a few key takeaways to remember. The No Surprises Act and implementing regulations provide important new protections for healthcare consumers, including prohibiting surprise medical bills in certain situations, taking consumers out of the dispute process between plans and issuers and out-of-network providers and facilities for covered services, requiring good faith estimates of expected charges, and providing a process for consumers to dispute charges that are significantly higher than the estimate. Also, expanding rights to the external review process, requiring certain information to be included on insurance ID cards, requiring provider directories to be kept up to date and providing help to consumers who rely on incorrect information. Consumers can get help from the No Surprises Help Desk by calling 1-800-985-3059 from 8 a.m. to 8 p.m. Eastern Time, 7 days a week, or by using the No Surprises online complaint form linked below.
Immediately following this session, you will be directed to a survey. CMS wants to hear from you. They want your feedback. So please do not hesitate to take a moment to submit any ideas, any suggestions, or feedback that you may have regarding the No Surprises Act and overview for assisters, advocates, agents, and brokers. Once again, Thank you so much for your time. Thank you for your participation today. Thank you for your questions. We hope that you all have a wonderful day. Thank you.